You are in a parked car outside an apartment complex, keys still in your hand, and an ICE officer asks, "Are you married to a US citizen?" Freeze right there. Most people hear that question and think, finally, the helpful fact. They blurt out names, dates, addresses, the whole story. But marriage can matter and still be dangerous to explain too quickly. The first mistake is answering before you know if you are free to leave, and before you assert your rights. A rushed answer becomes a statement becomes a record, and that record can affect detention, release, or removal proceedings. Because the safest first sentence is usually not the sentence people think it is. I am talking to you the way I would explain this at a kitchen table before anything goes wrong. I am an immigration lawyer, and this is public legal information, not legal advice for your specific case. Here is the deal. Being married to a US citizen may open a door. It may support a petition, a waiver, an adjustment case, or an argument in court. But it is not a badge. It does not automatically stop ICE from arresting you. It does not automatically stop detention. It does not erase prior orders, entries, criminal issues, or missed filings. So remember the takeaway. Do not lie, do not argue, do not volunteer extra facts, and ask for counsel before answering questions. So let's freeze the frame on the first sentence because this is where things change. The sentence is simple. I want to remain silent and I want to speak with a lawyer. Am I free to leave? That is the first move. Not the marriage answer, not the explanation, not my spouse is American. Rights first. Here is why. The question sounds narrow, but it can become a doorway. If you answer, yes, I am married to a US citizen, the next question may be, when did you enter? Then, how did you enter? Then, where do you live? Then, where do you work? Then, have you ever been ordered removed? Now you are not just talking about marriage. You are building a timeline for them. Entry, status, address, employment, prior immigration contact, maybe criminal history, maybe old paperwork you have not looked at in years. Casual answers are still answers. A nervous sentence in a driveway, at work, or in a hallway can end up in a report. And once it is written down, your lawyer may have to spend time fixing the damage instead of presenting the case cleanly. Remaining silent is not lying. Silence protects you. A false answer can create a separate problem with federal officers. So do not invent, do not guess, do not round the edges. You can provide documents later. You can explain marriage later. Your attorney can decide what matters. But here's where people get confused. If the marriage is real, why not lead with it? Because marriage does matter. A US citizen spouse may be able to file a petition for you. That petition can be a major part of an immigration case. In some situations, it can lead toward a green card. In other situations, it can support a request for release, discretion, or a better procedural posture. But it is not a force field. Immigration looks at more than the wedding ring. They look at how you entered the country, whether you were inspected at a port of entry, whether you are admissible, whether you have prior removal orders, whether there were fraud issues, whether there is criminal history, whether the marriage is real, and very important, whether anything has actually been filed. That last part is where people get into trouble. I am married to a US citizen and we have a pending case with receipts, is one conversation. I am married so I cannot be detained is a completely different conversation. One gives your lawyer something to verify, a receipt number, a filing date, a case type. The other sounds like you are claiming a protection the law may not give you. And even lawful permanent residents can face immigration consequences in certain circumstances. So if a green card is not always absolute protection, marriage by itself is definitely not automatic status. That is why the sequence matters. Rights first, lawyer next, documents after that, and now we get to the paperwork, because that is where a vague claim becomes something real. This is where things change, not because you said a magic sentence, because now there is something an officer can check. A US passport for your spouse is often the cleanest proof that the spouse is a US citizen. Photo, name, standard format, easy to recognize. A birth certificate may also prove citizenship, but on the street, in a rushed encounter, it can be harder to assess. No photo, different state formats, more room for confusion. So if the point is, my spouse is a US citizen, proof of the spouse's citizenship matters. But that is not the same thing as proof of your immigration process. For the non-citizen spouse, useful documents are different. Receipt notices, a green card, a work permit, approval notices, court paperwork, attorney contact information, anything with a case number, filing date, or agency heading. Officers do not make decisions just because someone says, "My spouse is American." They look at records, databases, documents, and what they can verify quickly. That is why a receipt notice can change the conversation more than a long explanation. Bad version: I am married, I have a case, it is complicated, let me explain. Better version: I want to remain silent, I want to speak with my lawyer. My attorney's information and case receipts are here. Calm, short, verifiable. But even with documents, there is one thing you should not do. Start narrating your whole immigration history, because oversharing is the trap. An officer asks, "Are you married to a U.S. citizen?" And the nervous answer becomes, "Yes, we got married in 2021, but I came in before that, and I worked for a while, and we moved twice, and my old lawyer filed something, but I missed a notice." Stop. You may think more detail makes you look honest. But now you have handed over dates of entry, manner of entry, unauthorized work, old addresses, maybe even a clue about a prior order or a missed hearing. That is not background noise. That is a lead. Officers do not need your whole life story to start checking records. One sentence can give them a timeline. One timeline can create a contradiction. One contradiction can become the thing your lawyer spends the next 6 months trying to explain. The better version is boring on purpose. I want to remain silent. I want to speak with my lawyer. Here is my identification. Here is my attorney's information. If documents are legally required, or if your lawyer has told you to carry certain proof, provide them calmly, but do not narrate your file on the sidewalk. The question is not whether being married to a U.S. citizen matters. It is whether saying it at the wrong time, in the wrong way, can make your situation worse before it helps. Now let's talk about the situation that looks similar but is legally completely different, when the person stopped is actually a U.S. citizen. If you are the U.S. citizen spouse, the legal baseline is simple. ICE does not have authority to deport you. You are not removable. Your marriage is not what protects you. Your citizenship is, but that fact may not end the encounter in the first 10 seconds. Officers may still ask questions, they may still be trying to identify who is who, and citizens have been mistakenly detained before, which is why calm proof matters even when the law is on your side. Immigration attorneys often point out that U.S. citizens generally do not have to prove citizenship on the sidewalk, but if you choose to show proof, a U.S. passport is usually the strongest practical document. Not a speech, not a debate, a passport. Bad version: you cannot talk to my spouse, I am a citizen, get away from us. Now everyone is louder. Now the focus shifts to your behavior. Better version: I am a U.S. citizen. I do not consent to a search. I want to speak with a lawyer. Then document names, badge numbers if possible, time, location, vehicles, and what was said. Do not grab anyone. Do not block anyone. Call a lawyer immediately. And that brings us to the bigger lesson. Because the real villain here is not one question. The real villain is bad sequencing. Not marriage, not even the question, the order. In these encounters, people panic and start offering a whole life story. Where they met, when they filed, why they moved, who pays rent. Now you have created extra statements, extra details, and extra chances for something to sound inconsistent later. Here is the cleaner sequence. Rights first, silence second, lawyer third, documents fourth, explanation last. Had they led with that, the record may have been cleaner. The lawyer may have had less damage to undo. And no, calm sequencing does not guarantee release, but it does reduce self-inflicted damage. So now we can finally answer the opening question directly. So here is the answer. If ICE asks, "Are you married to a U.S. citizen?" do not lie. But say this first. I want to remain silent. I want to speak with a lawyer, and I need to know if I am free to leave. Then stop talking. If your lawyer advises it, or if documents need to be shown, show documents. Marriage certificate, receipt notices, identification, attorney information. Not a speech. Because marriage can matter, it just does not automatically protect you. Documents help, but sequencing helps protect you from unnecessary admissions. Share this with someone in a mixed status family, save the words, and comment with the question they are most worried about.